Hi, my name is Levitt Brown. I am a student at William Woods University, enrolled in the master's program for athletic administration and activities. Today I am doing a video presentation for my sports law class. This case involves the Title IX. This case is very interesting in that both the plaintiff and the defendant are claiming Title IX violations versus each other. It is important that first we discuss Title IX. In 1974, Congress requested that the Secretary of the Department of Health, Education, and Welfare prepare and publish regulations implementing the provisions of Title IX, including with respect to intercollegiate athletic activities, reasonable preventions considering the nature of particular sports. Chief among their primary concern is whether the selection of sports and levels of competition effectively accommodate the interests and abilities of the members of both sexes. They list 9 factors. An institution may violate Title IX solely by failing to accommodate effectively the interests and abilities of student athletes of both sexes. In 1979, the Department of Health and Education and Welfare, in an effort to encourage self-policing, issued a policy interpretation providing guidance of what constitutes compliance with the law. According to the policy interpretations, an institution has effectively accommodated the interests of its male and female students if it satisfies 3 benchmarks. 1, which is important because the court will make a decision later in this presentation on number 1, whether intercollegiate level participation opportunities for male and female students are provided in numbers substantially proportionate to their prospective enrollments, or 2, where the members of one sex have been and are unrepresented among the institution can show a history and continuing practice of program expansion that is demonstratively responsive to the developing interests and abilities of the members of that sex. This is important also because the university is claiming that this is what they're attempting to do. Or 3, where the members of one sex are unrepresented among intercollegiate athletes and the institution cannot show a continuing practice of program expansion, where it can be demonstrated that the interests and abilities of the members of that sex have been fully and effectively accommodated by the present program. And this is what the university is attempting to, their argument is that what they are attempting to do, and that is give the underrepresented more opportunities. On May 7th of 1993, the University of Illinois announced that it intended to terminate 4 varsity athletic programs: men's swimming, men's fencing, men's and women's diving. And this was to be effective on July 1 of 1993. On May 25th of 1993, the plaintiffs, William M. Kelley, and all the members of the men's swimming team, prior to the termination of the swimming program, brought a suit against the Board of Trustees of the university, its chancellor, its athletic director, and they're alleging that the defendants violated Title IX of the Education Amendments of 1972 and the Equal Protection Clause of the 14th Amendment. The plaintiff's complaint sought damages, as well as an injunction prohibiting the defendants from terminating the men's swimming program. The defendants responded by filing a motion to dismiss, and both parties agreed to a summary judgment. The district court granted summary judgment in favor of the defendants and found that the preliminary injunction was therefore moot. The plaintiffs appealed to a higher court. The plaintiff's argument is that the defendants discriminated against the men's swimming team because the school eliminated the program solely because it is a male program, which is in violation of Title IX and the Equal Protection Clause of the 14th Amendment, which provides for protection for discriminating against both sexes. The defendants countered with an argument that yes, they did eliminate the men's program, but it was for several factors. And yes, one of those factors was based on the fact that the men's swimming program is a male program. They cited that in 1982, the Office of Civil Rights of the United States Department of Education determined that their university had denied its female students equal athletic opportunities. And relying on the university's representation that it would remedy the disparity within a reasonable period of time, the Office of Civil Rights concluded that the school was not in violation of Title IX, which Title IX gives the school the opportunity to correct such disparities. However, the school states that a decade later, they were not in compliance. And in fact, the school stated the female participation in intercollegiate athletics at the university continued to be disproportionate to female undergraduate enrollment. They cited statistics. They cited that here in 1993, women comprised of 44% of the student body of the university. They however, only accounted for 23.4% of the school's intercollegiate athletes. They argued that it was against this backdrop that the decision to cut the men's swimming program was made, and for the reason of being faced with a significant deficit of its budget, which was about $600,000. For that reason, it gave the university the opportunity to comply with the Title IX, counting male programs to address female proportion numbers compared to male proportionate numbers, and to reduce athletic costs significantly. The plaintiff also argued that the percentage of women involved in intercollegiate athletics at the university is substantially lower than the percentage of the women enrolled at the school. And if the university had terminated the women's swimming program, it would have been vulnerable to a finding that it was in violation of Title IX. Female participation would have continued to be substantially disproportionate to female enrollment, and the women would demonstrate an interest in intercollegiate athletic activity and demonstrate ability to compete at the intercollegiate level would have been left without an opportunity to participate in their sport. They argued that the university could, however, eliminate the men's swimming program without violating the Title IX, since even after eliminating the program, men's participation in athletics would continue to be more than substantially proportionate to their presence in the university's student body. And the appealing court agreed in that the law makes clear if the percentage of the students of that sex in the general population, the athletic interest of that sex is presumed to have been accommodated. The university's decision to retain the women's swimming program, even though budget constraints required that the men's swimming program be terminated for reasonable response. So the court actually sided with the defendants in this case. The court decision was that to defer the agency's interpretation that the issue here meets is that the measuring compliance through an evaluation of a school's allocation of its athletic resources allows school flexibility in meeting the athletics interests of their students and increases the chance that the actual interests of those students will be met. And if compliance with the Title IX is to be measured through this sort of analysis, it is only practical that the school be given some clear way to establish that they have satisfied the requirements of the statute. The substantial proportionality contained in benchmark 1 merely establishes such a safe harbor. Since the policy's interpretations maps out a reasonable compliance with Title IX, the court decided that they did not have an authority to condemn it, and that the plaintiffs claim that the University of Illinois violated Title IX when it terminated the men's swimming program is therefore rejected. So what the court did was basically they stated that they could do what they did because they were in compliance with Title IX. It is important that athletic administrators understand Title IX because you could end up in a situation of litigations. There is a lot of information online about Title IX, and I would suggest that athletic administrators go in and look at Title IX and see if they pass what they call the 3-prong test. Thank you for watching my video presentation.